Well, good morning again. It's 10:15, so we will begin with our second panel of the morning, again placing Alabama's constitutions into a historical context. And we have two distinguished speakers this morning. The first, Dr. Richard Bailey, is a Bicentennial Scholar of the Alabama Humanities Foundation. He received his BS and Master of Education degrees from Alabama State University in 1971 and 1972. His Master of Arts degree from Atlanta University in 1973, and his PhD from Kansas State University in 1984. His scholarly interests have focused on African American history in Alabama and Reconstruction in Alabama. He is the author of two books, Neither Carpetbaggers Nor Scalawags, Black Office Holders During the Reconstruction of Alabama, 1867 to 1878, and They Too Call Alabama Home, African American Profiles, 1800 to 1999. He is a frequent lecturer and speaker and appears often on TV and radio to discuss Alabama history, Southern history, and contemporary issues. And his talk this morning is entitled A Guiding Light, Constitutional Developments in Alabama from 1819 to 1901. And then our second speaker, Dr. Stephen P. Brown, is also a Bicentennial Scholar of the Alabama Humanities Foundation. He received his BA from Brigham Young University in 1991, his Master of Arts and PhD degrees from the University of Virginia in 1995 and 1998, and he has taught at Auburn University since 1998, where his courses focus on American constitutional law, religion and politics, law and society, and American government. His scholarly interests include church and state issues and American legal history. His 2002 book, Trumping Religion, The New Christian Right, the Free Speech Clause, and the Courts, received the National Communication Association's Franklin S. Hayman Award for Distinguished Scholarship in Freedom of Expression. His 2016 article, The Girard Will and Twin Landmarks of Supreme Court History, received the Supreme Court Historical Society's 2017 Hughes Gossett Senior Prize, which was presented by Chief Justice John Roberts. He currently has a traveling exhibit about landmark Supreme Court cases from Alabama, which is touring throughout the state during the 2019 Bicentennial of Alabama statehood. Please welcome both of our speakers, and Dr. Bailey will be the first to speak.
Good morning. Thank you very much for that wonderful introduction. I'm going to move quite rapidly here to
just scroll down. So every time you scroll down, it'll go
this way.
Yeah.
Okay. I guess I'm getting ahead of myself. Take it back to the beginning. Okay, all right. Okay. As you can see, the title for my presentation here today is A Guiding Light, Constitution Making in Alabama, and I'm going to repeat some of the things you've already heard and emphasize some other things, but what I want to do is just give an overview of constitutional development in Alabama from the very first Constitution in 1819 to the current Constitution under which we are working today, the one of 1901. And the first point that you have here on the screen is Alabama's sixth Constitution. The Constitution of 1819 is the one that carried us from our territorial status to statehood. The Constitution of 1861, better known as the Secession Constitution, the one of 1865, the first post-Civil War document, the one of 1868, readmission to statehood, the one of 1875, redemption, and the one of 1901, majority rule. And I think most of you know I could have given that Constitution many other names. Let's look at some of these constitutions. I took a couple of things from each one just to give you a feel for some of the characteristics or provisions of each constitution. If you look at my first one, popular elections, we have that for the Constitution of 1868, 1875, and 1901. And universal white manhood suffrage, the one of 1819, and all of them, in fact. And then enlarged electorate, we start in 1868, and I'm going to explain that further as we go along. And then decreased electorate, we have that one for the Constitution of 1901. Women's rights in particular begins in 1868 Constitution. A poll tax for education, Constitution of 1868 as well as the Constitution of 1875. A poll tax for voting, Constitution of 1901. Homestead exemption, you see that, the Constitution of 1868. Black suffrage begins with the Constitution of 1868. Property qualification for voting, you see when that begins, 1901. And then we have the provision regarding vacancy and petty crimes. And then we have the one for that emphasizes democracy. I have that listed for the Constitution of 1819. One of the small points I just want to emphasize here, when I list provisions for debtors, in 2019, we may take it for granted, but at one point, some bad things could happen to you if you were in debt. And what we want to emphasize here is the provisions that our constitutions have made over time regarding debtors. One could not be in prison for a debt. And you can see, beginning with the Constitution of 1868, no imprisonment for debt, the Constitution of 1875, no imprisonment for debt, et cetera, et cetera. This is a big deal. And I just want to let you know the position of each one of these constitutions regarding imprisonment for debt. Before we begin to talk about the Constitution of 1819, let's look at the population of Alabama beginning in 1820. And you can see the population of the state, the white population, the African American population, and the number of slaves in the state of Alabama, as well as the number of free blacks in the state of Alabama. And these numbers become more crucial as we march up to 1901. The Constitution of 1819. If we could go back in time and just reflect on what this state was like in 1819, it might be difficult for us to embrace the fact that the Constitution of 1819 was a liberal constitution for that time period. You had universal white manhood suffrage, but you had no qualifications for voting and many other things that were unheard of for that day. But the point of the matter is that the Constitution of 1901 for Alabama was considered a liberal document by the standards of that time. And what I want to do is ask the question, as I begin to talk about all of these constitutions, When you look at the Constitution of 1901, 1819, and move to the Constitution of 1901, my question to you, are we making progress or are we going backwards? From 1819 to 1901, based on what we're going to say here this morning, does it seem like we're going forward or are we going backwards? Let's look at the provisions this Constitution makes for slavery. The General Assembly shall have no power to pass laws for the emancipation of slaves without the consent of their owners or without paying their owners previous to such emancipation. Now, this on the surface is consistent with the time, okay? Let's go a step further. Look at this, Section 2. In the prosecution of slaves for crimes or of a higher grade than petty larceny, the General Assembly shall have no power to deprive them of an impartial trial by a petty jury, which means then that slaves in Alabama were entitled to a trial by jury. And then the General Assembly shall have no power to pass laws for the emancipation of slaves without the consent of their owners or without paying their owners previous to such emancipation. In other words, I think that's clear. If you want to emancipate a slave, you must pay the owner. But the point is, there is a discussion in Alabama regarding slaves. Section 2, in the prosecution of slaves for crimes of a higher grade than I just read that. Number 3, any person who shall maliciously dismember or deprive a slave life shall suffer such punishment as would be inflicted in the case the like offense had been committed on a free white person. No distinction made here, no distinction whatsoever. Then we move to 1860, and we see the white population, the population of the state, the white population, African-American population, the slave population, and then the free black population, which stood at 2690 in 1860, the urban population for the state of Alabama, as well as the rural population for the state of Alabama. This is the 1861 convention. The Constitution and that convention, it presents a watershed period in Alabama history. What we have here is the Ordinance of Secession adopted by the Alabama Constitutional Convention of 1861. This spells it out, the fact that Alabama is withdrawing from the Union. Section 1, be it declared and ordained by the people of the state of Alabama in convention assembled that the state of Alabama now withdraws and is hereby withdrawn from the Union known as the United States of America, and henceforth ceases to be one of the said United States, and is and of right ought to be a sovereign and independent state. Chapter 1, again, this is what I just said. Here are some other provisions that the Constitution, this Secession Constitution, makes for slaves. Section 1, no slave in the state shall be emancipated by an act done to take effect in this state or any other country. Section 2, the humane treatment of slaves shall be secured by law. And number 3, laws may be enacted to prohibit the introduction into this state of slaves who have committed high crimes in other states or territories, and to regulate or prevent the introduction of slaves into the state as merchandise. Number 3, be it ordained by the people of Alabama in convention assembled that the Constitution framed and adopted on the 11th day of March, 1861, by the deputies from the state of South Carolina, Georgia, Florida, Alabama, Mississippi, Louisiana, and Texas, in convention assembled at Montgomery, Alabama, be and the same is hereby approved, ratified, and adopted as the federal Constitution of the people of Alabama. This is the adoption of that Constitution of 1861. Constitution of 1865. This is the state's first post-Civil War Constitution. An Alabama Constitutional Convention approves a new state constitution that abolishes slavery but does not guarantee black civil rights, causing consternation in the North, even though the state legislature justifies or ratifies the 13th Amendment to the U.S. Constitution. Article 1, Declaration of Rights, Section 34, that hereafter there should be in the state of Alabama neither slavery nor involuntary servitude otherwise than for the punishment of crime whereof the party shall have been duly convicted. And what's going on here, and we just want to talk for a minute, is a kind of justification that these delegates have written into the Constitution to ensure that no one assumes that anyone in Alabama plans to try to re-enslave African Americans. Section 35, that the right of suffrage shall be protected by laws regulating ejections and prohibiting under adequate penalties all undue influence from power, bribery, tumult, or other improper conduct. So you can see these people are trying to give former slaves in the state of Alabama some kind of protection. Article 4, the Legislative Department, Section 5, representation shall be chosen for the term of 2 years, and no person shall be a representative who is not a white person, 21 years of age, a citizen of the United States, and one who has been an inhabitant of this state for 2 years next preceding the election. Section 31, it shall be the duty of the Attorney General at the next session and from time to time thereafter, as it may deem proper, to enact laws prohibiting the intermarriage of white and with a white person with Negroes or persons of mixed blood. Article 4, Section 36, it shall be the duty of the General Assembly at its next session and from time to time thereafter to enact a law that will protect the freedmen of this state in the full enjoyment of all their rights, right of persons and property, and guard them and the state against any evils that may arise from their Southern emancipation. Here again, the Constitution is trying to send forth a message regarding the status of freedmen. Article 5, Executive Department, Section 4, the governor shall hold his office for the term of 2 years from the time of his installation and until a successor shall be qualified. One of the points we want to emphasize here is that the governor is serving a term of 2 years instead of the 4 years that the governor serves today. Article 8, election by the people. Every white male, and this is the point we want to emphasize with this, is still restricted the voting or the franchise to white males. The Constitution of 1868, someone has mentioned earlier this morning that the Constitution of 1901 is perhaps one of the most controversial constitutions in this state, but the Constitution of 1868 gets its share of what we might call negative publicity also, because this is the first time in Alabama history, the Constitution of 1868 we're talking about, in which African Americans had the opportunity to vote. And this is the time of the carpetbaggers and the scalawags and these black delegates to the Constitutional Convention of 1867. So some of that controversy has to do with some of the persons who were responsible for helping to write this Constitution. Section 34 says that hereafter there shall be in this state neither slavery nor involuntary servitude, trying to send a clear message, because after all, the 14th Amendment is one of the amendments that has to be ratified by the delegates to the Constitutional Convention of 1867. So the Constitution of 1868 must have some kind of provision in there if the states to be readmitted into statehood regarding adoption of the 14th Amendment. Declaration of Rights, that no form of slavery shall exist in this state, and there shall be no involuntary servitude. Here again, this is what the 13th Amendment is all about, that was adopted in the state of Alabama in December 1865. Section 36, the right of suffrage shall be protected in laws registering regarding elections and prohibiting under adequate penalties all undue influences from power, bribery, tumult, or other improper conduct. So you can see the state is trying to send a message that the days of slavery are over. And then we go to Article 4, the legislative department. There should be the duty of the General Assembly at its next session and from time to time thereafter, as it may deem proper, to enact laws prohibiting intermarriage. So we have another instance in which is being made clear that this state will not tolerate intermarriage. Executive Department, Article 4, Section 1, the Executive Department will and shall consist of a governor, a lieutenant governor, secretary of state, auditor, treasurer, and attorney general. This is the first time in Alabama history we're going to get a lieutenant governor. Persons in the white persons in the state of Alabama had to take a loyalty oath before they could be allowed to vote. And that loyalty oath is listed in Section 4, but at the same time, they had to let it be known that at no point had they ever, that they would swear not to take up arms against the United States. Election by the people, Article 8, every white male persons of the age of 20 and upward who shall be a citizen of the United States and shall have resided in this state 1 year next preceding the election and the next month thereof in the country in which he offers to vote shall be deemed a qualified elector. Number 11, education. This is a controversial issue. The common school and other educational institutions of the state shall be under the management of a board of education. This is the first time we get a board of education in the state of Alabama, consisting of a superintendent of public instruction and 2 members from each congressional district. Section 6, it shall be the duty of the Board of Education to establish throughout the state in each township or other school district which it may created 1 or more schools at which the children of the state between the ages of 5 and 21 years may attend free of charge. And as you read here, one of the points that is made is that the schools will be segregated in the state of Alabama. Exempted property. If we just discuss the fact that the Constitution of 1819 is liberal, when it comes to exempted property, Article 14, Section 6, this provision makes the Constitution of 1868 one worth talking about, because before 1868, when a female married in the state of Alabama, her property became the property of her husband. But with this Constitution, the female was able to retain her property. Another point that some of the opponents of the Constitution of 1868 have really driven home is that it was never really ratified by the people. And you can read something even today where persons are still saying that Constitution, the one of 1868, was not ratified by the voting population in the state of Alabama, by the electorate in the state of Alabama. 1870, the state population, the urban population, the African American population, the rural population, and the number of cotton productions. And this is the Constitution of 1875. And one of the main purpose of the Constitution of 1875 was to ensure that as much as possible, whatever could be dealt away with regarding the Constitution of 1868 would be done, that no form of slavery shall exist in the state, and there shall be no involuntary servitude. One of the reasons to put this into the Constitution, and many other things I will discuss just briefly, is to ensure there is no federal intervention in the state of Alabama. Make certain whatever we do to erode black rights does not draw the wrath and the attention of the federal government. In other words, bring these federal troops to bear on the state of Alabama. The right of suffrage shall be protected by laws regulating election and prohibiting under adequate penalties all undue interference from power, bribery, tolment, or other improper conduct. The people of the state accept as final established fact that from the federal union there can be no secession of any state. I think this is clear. We're sending the message that the state of Alabama does not plan to secede from the union. Number 35, the people of this state, number 38, the educational property qualification for suffrage for office, nor any restraint upon the same on account of race, color, or previous condition of servitude shall be made by law. The Legislative Department, Article 4, a member of either house expelled for corruption shall not thereafter be eligible to either house, and punishment for contempt of disorderly behavior shall not bar an indictment for the same offense. What is happening here is this is one way of dealing with all of the chicanery, the bribery, and whatever that was taking place during Reconstruction. And this is the Constitution's way of actually ensuring that these persons who may be so accused will never hold public office in the state of Alabama. Article 5, Executive Department, Section 1, the Executive Department shall consist of a governor, a secretary of state, state treasurer, state auditor, attorney general, and superintendent of education, and a sheriff for each county. If you notice, the lieutenant governor's office is not listed here. There is no lieutenant governor beginning with the Constitution of 1875 in the state of Alabama. The governor, secretary of state, state treasurer, state auditor, and attorney general shall hold their prospective offices for the term of 2 years from time of their installation of office and until their successors shall be elected and qualified. So you can see lieutenant governor's position is gone. Article 8, suffrage and election. Every male citizen of the United States. Now we see that we don't have any reference to a white person being the only person who's qualified to vote in the state of Alabama. Education. The General Assembly shall establish, organize, and maintain a system of public schools throughout the state for the equal benefit of the children thereof between the ages of 7 and 21 years, but separate schools shall be provided for the children of citizens of African descent. This goes back to the Constitutional Convention of 1867. That was the first time that the delegates there could have decided regarding intermarriage, separate schools, or miscegenation, whatever the case may be. But what they decided to do, that Constitutional Convention of 1867, was to leave to subsequent bodies the issue of integrated or segregated schools and intermarriage and some other issues that we are still dealing with today in the state of Alabama. The Constitution one of the things that the delegates to the Constitutional Convention of 1875 did was to ensure that as many offices as possible they could take off the books, and as many provisions as possible that dealt with any kind of aid to the poor would be taken off the books as well. And what we have here is a chart for the Freedmen's Hospital that was located in the state of Alabama near Talladega to show you how the funding actually decreased over years from 1869 with $4,019.98 to $165.55 in 1876. In other words, after 1876, the Freedmen's Hospital was no more. You can see the black-white populations for 1900 and the urban population as well as the rural population. And I'm just going to end my conversation, discussion here this morning, saying something general about the Constitutional Convention of 1901. It's already been stated that John B. Knox was the president of that convention, and that convention had as its primary purpose the establishment of white supremacy in the state of Alabama. Thank you very much.
All right, well, I'm grateful for the opportunity I have to be here and address you for a few minutes today, ladies and gentlemen. If I could, I'd like to just make one quick comment about something Dr. Campbell said about this exhibit that was sponsored by the Alabama Archives as well as the Alabama Bicentennial Commission of great Supreme Court cases from Alabama. It's over in Tuskegee right now at the George Washington Carver Museum, and it's going to talk about Scottsboro, and it talks about Frontero versus Richardson, and it's going to talk about New York Times versus Sullivan, several other different cases from Alabama. It's going to talk about John McKinley, the first U.S. Supreme Court justice from Alabama that was appointed in 1837, John Archibald Campbell that was appointed in 1853, and also Hugo Black, who's appointed in 1937. But it talks a lot about people and cases that a lot of folks, even lawyers, aren't always familiar with. And it is going to address a couple of cases that deal and come directly out of the Alabama state constitution. So, as we've talked about already, the 1901 Constitution, I should say, that 1901 Constitution deserves to be criticized, has been heavily criticized for a century. More than that, because of its ridiculous limitations on home rule, because of its framers and its motivations, and also certainly because of things in the original document as well as in some of the amendments that just aren't appropriate, aren't right, and again deserve that criticism. As a political scientist, though, what I very much appreciate about the 1901 Constitution in a kind of weird way is that underlying its description of the executive branch responsibilities and legislative and judicial responsibilities and things like that is the fact that voting is power. That's a theme that is from start to finish in that 1901 document, that voting is power. Now, granted, the 1901 framers tried to ensure that African American citizens did not wield that power, at least not in enough numbers, as we've heard already, to be able to influence their own political authority. But in doing so, they basically say voting is power, and they underscore an idea that's been part of democracy going back to ancient Athens 2,700 years ago. Citizen participation in their government, all right, and the way we do it primarily through voting is critical. So again, the Supreme Court in its rulings of Gomillion versus Lightfoot and Reynolds v. Sims, the two cases I'm going to talk about today, and that are also in this exhibit that's over in Tuskegee, reemphasize that point about voting and voting as power and citizen participation in government. Now, I never cease to be astonished when I read the minutes of the 1901 Constitutional Convention. Dr. Mendenhall already addressed, as did Dr. Bailey, about John Knox. But when we talk about that this Constitutional Convention was brought about for the purposes of white supremacy, people might say, well, did they kind of get around to it? Was that the subtext? Or, how are we supposed to interpret that comment? And I'll tell you how, all right? On May 22nd, 1901, the first full day of business after the opening prayer and after the roll call of delegates was taken, John Knox stood and said this. Begins his talk this way. In my judgment, the people of Alabama have been called upon to face no more important situation than now confronts us, unless it be when they, in 1861, stirred by the momentous issue of impending conflict between the North and the South, were forced to decide whether they would remain in or withdraw from the Union. Then, as now, the Negro was a prominent factor in the issue. Very first statement of the very first order of business by the president of the convention. He goes on to say, within the limits imposed by the federal constitution, our responsibility is to, quote, establish white supremacy in this state. So how do we do that? Well, he says we need to be careful. We saw what happened with Reconstruction. We saw when government foisted institutions and ideas and things that were very much offensive to the populace of Alabama. So he said, if we would have white supremacy, this is a quote, we must establish it by law, not by force or fraud, unquote. He encouraged the delegates to look to Georgia, look to the Carolinas, look to Louisiana, look to Massachusetts, look to other states that have imposed restrictions on voting throughout the country. And again, this is something I tell my students, that the South was not the only one that did this. The South gets the knock on it, but poll taxes started up north. Literacy tests started up north. The Supreme Court upheld those and other voting restrictions as for different reasons, but when they were applied on racial grounds is when the Supreme Court began to strike those things down. But we didn't invent any of that stuff in the South. All those were done elsewhere. And so he says, look to those places and let's figure out how we can regulate and restrict the vote. And as we've already heard, part of that that comes out of that, of course, is the poll tax, is the property and literacy requirements. Were race neutral on their face, obviously. They didn't specify that it would be African Americans would be afflicted primarily by this, but as was already pointed out by Dr. Reiser, tremendous, devastating consequences. In the state and federal elections of 1900, some 100,000 African American citizens of Alabama voted. In 1904, just 1 year after the new Constitution went into effect, there were only 3,654 qualified black voters in the state. All right, in 4 years, you go from 100,000 voting, I don't know how many qualified to vote, 100,000 voting to 3,600 that are qualified to vote. And so that's how devastating the impact of these restrictive measures were. Now, some of these requirements were modified, and others were struck down, as has been mentioned by the courts here. But this is the background. This is 5 decades of history that now play in Alabama as well as in Tuskegee and Macon County, where Gomillion versus Lightfoot originated. In the mid-1950s, Macon County's population was about 30,000 people, 27,000 of whom were African Americans. But white voters outnumbered black voters by a 2-to-1 margin. You have the burgeoning civil rights movement that is propelling African Americans to try to seek the vote, and they do by increasing numbers. But both sides, both races in Macon County see what's going to happen if African Americans increasingly get the vote. What's going to happen to the balance of power in that area? And so you have local officials again, and Dr. Reiser talked about the power of registrars, of county registrars, but you have throughout Alabama, but in particular in this instance, where you have officials that took informal and informal steps to limit the accessibility of African Americans to register to vote. African Americans who experienced no problems whatsoever registering to vote in other states found themselves stymied in Alabama, and particularly Macon County, when they went to register. One Tuskegee Institute professor in a very famous account said, quote, "I can understand why one must demonstrate his literacy, but it didn't take me that long to demonstrate my competency in French, and German as well, for that matter, when I took my PhD exams at Boston University." Okay, so again, how do you fail a PhD, a doctor of a professor there at Tuskegee? Prospective black voters were given numbers. Again, famous accounts you guys have all heard of, where an African American woman was given the number 17, and figured she'd be right there when they'd call her name. Wasn't called till mid-October. This got the number 17 in June. Was not able to vote or able to register until mid-June. Registrar officials, knowing that if they didn't have a quorum, they could not sit, would call in sick. They would have truncated hours. They'd show up late. They'd leave early. They would change the location of their where the registration was to take place. Again, a very famous example, Macon County Courthouse on a particular day when black voters were supposed to show up in the designated area, were told, well, the room's under construction. You're going to have to find the other location in the courthouse. Didn't tell them where it was. They finally find where the black individuals were supposed to register to vote in the Macon County Courthouse in the probate judge's office in his walk-in vault. And trying to find that with no signs was just ridiculous, but that's kind of the sort of thing that happened here. So at any rate, even with all these crazy things happening, you do have, bit by bit, little by little, person by person, the number of voters who are increasing, black voters who are increasing in Macon County. And so that leads then Senator Sam Engelhardt, a state senator from Macon County, to seeing the writing on the wall, seeing that the balance of power on the basis of race would shift. He goes ahead and submits a bill in the state legislature that effectively gerrymanders Tuskegee. Tuskegee, the city of Tuskegee was founded, and up until this time was 2.5 square miles, all right? The gerrymander went ahead from a 4-sided square to a 28-sided figure that went down this road and in this neighborhood, went over here, effectively wiped out and took out of Tuskegee's boundaries every black neighborhood. The Tuskegee Institute was not in Tuskegee anymore, all right? You had about 4 African-American voters that were left in the town. The masterstroke to all this wasn't that it was that it would ensure white power, and it wasn't that there would be any controversy in Alabama. Would anybody care? That wasn't the issue. The issue was the Supreme Court wouldn't touch it, and he knew that. And the legislators that passed the Tuskegee gerrymander bill, this passed the state legislature without hearings, without any debate, and without a single dissenting vote in both houses of the Alabama legislature. The masterstroke was the Supreme Court would not touch it because for 150 years the court had said we don't do redistricting. Okay, we don't step into line drawing and boundary drawing of legislative districts, state or federal. We don't step into apportionment issues. That's a local government, state government, party-affiliated affair, and we don't step into that. So again, in that sense, Engelhardt was right. The likelihood of the Supreme Court taking this case and doing anything about it was quite remote. Just a few years earlier, in 1946, the Supreme Court had considered a challenge to badly malapportioned districts in Illinois, and I'll talk about that in a little more detail in a second. But in writing for a narrow majority in Cold Grove versus Green, Justice Felix Frankfurter invoked the political question doctrine to declare there's nothing the court could do to help Illinois voters who were voting in represented malapportioned districts. He said, nothing is clearer than that this controversy concerns matters that bring courts into immediate and active relations with party contests. It's hostile to a democratic system to involve the judiciary in the politics of the people. Citizens, political parties, even Congress could properly intervene to correct this, but courts, Frankfurter warned, ought not to enter the political thicket. And so again, that phrase, the political thicket, had governed apportionment issues, redistricting issues, and other things until you get into Gomillion. So Charles Gomillion and the Tuskegee Civic Association go ahead and challenge Tuskegee gerrymander. Their first hearings before U.S. District Judge Frank Johnson. Couldn't have found a more sympathetic judge for this issue anywhere in Alabama. Frank Johnson, though, rules against them. And he rules against them because he said, we all understand what the purpose of this was. We all understand the motivations for it. But when you look at the authority of the state legislature to do this, it's pretty clear. And he hauls out Article 2, Section 104, subsection 18 of the 1901 Constitution, which states clearly that, quote, the legislature is not prohibited from altering or rearranging the boundaries of a city, town, or village. Okay, he said we don't need to hide the motivation, we don't need to ignore it, but he went on to write, quote, I have no control, no supervision over, and no power to change any boundaries fixed by a duly convened and elected legislative body, unquote. Now, is upheld on appeal to the Fifth Circuit Court. So it goes to the Supreme Court, and the Supreme Court, in that case, by a unanimous opinion, 9-0, overturns that. So how do you get from the political thicket, okay? How do you get from the political question doctrine to the court stepping in here? And the court said, well, there's constitutional infractions, and then there are the political doctrine, the political question doctrine, and if the constitutional infraction will trump that, okay? The Court says when a state exercises power wholly within the domain of state interest, it's insulated from federal judicial review. But such insulation is not carried over when state power is used as an instrument for circumventing a federally protected right. What the court has said previously is equally applicable here. Acts generally lawful may become unlawful when done to accomplish an unlawful end. And a constitutional power cannot be used by way of condition to attain an unconstitutional result. So the result of Gomillion is twofold. The first, of course, is that Tuskegee's boundaries go back to that four-sided square. More importantly, though, this is the first step of the court stepping into that political thicket, all right, saying there might be instances where the Supreme Court must step in and look at the way boundaries are drawn, and then later, as the court will say, the way that representatives are apportioned in that sense. The situation in Tuskegee was so egregious, the court simply felt that it simply could not step in. But you had other justices in Gomillion that basically said, is there that much of a difference between depriving somebody of a right to vote, as in the Tuskegee gerrymander case, and diluting their vote to such an extent that their vote doesn't matter. And that is what happens now in Reynolds versus Sims. The story behind Reynolds versus Sims is a simple one. The Alabama Constitution 1901 requires that legislative seats be reapportioned after every census, and for 60 years, the Alabama legislature refused to do so. That's the story, all right? 60 years, they simply refused to. You have, for all its flaws, and there's a bunch, the 1901 Constitution does acknowledge apportionment and how important it is. In fact, Article 9 deals with representation in both houses of the legislature. Section 198, 199, Section 200, Section 201, Section 205, if I'm not mistaken, all have different aspects which talk about apportionment. In fact, as Section 201 says, if for some reason the federal government can't kick out a census at a particular time, Alabama should have its own. And on the basis of that Alabama census, should go ahead and reapportion the seats in the state legislature. So why was nothing done? Well, it goes back again to, and we don't have time to discuss this now, but the Big Mule and Black Belt political coalition, the very group that brought together the 1901 Constitution, simply, with the power they wielded in the state legislature, were able to prevent any serious work to reapportion seats from going forward. All right, and again, why? Because voting is power, and that applies to state legislators who hold power and are able to control votes and control agendas as much as it applies to you and me. Over the course of 60 years, between 1900 and 1901, you have tremendous demographic shifts that are happening. Not only African Americans are leaving the state in droves and heading up north as part of the Great Migration, as African Americans left the Deep South for jobs and equality up north and out west. But within the state, the rural population of the state is shifting now to the urban areas. And it does so to such an extent that the representation in the state legislature is badly malapportioned. So let me give you some examples of this. In 1960, in Lowndes County, had one seat in the Alabama Senate for 15,000 citizens. In 1900, Lowndes County had 35,000 people and still had that single senator. Okay, so they've kept that representation in the Senate that whole time. A single senator had represented Jefferson County in 1900 as well, but by 1960 has 600,000 people in Jefferson County and still has a single senator. That's what malapportionment means, okay? In the House, the same thing. Bullock County had 13,000 citizens in 1960, sent 2 representatives to the House, as it had in 1900 when it had 31,000. Mobile in 1960 had 314,000 citizens and only sent 3 representatives to the House. So how do you get Bullock County with 13,000 sending 2 and representatives to the House of Representatives at the state level, and Mobile is only able to only have 3 representatives for its 314,000. All right, so malapportioned was the state legislature that a majority of legislators in the House and the Senate came from areas that held only 25% of the population. And so I need to point out, though, that this was not unique. Reynolds v. Alabama, Reynolds v. Sims, I should say, which was the case the Supreme Court took that looked at this, was very characteristic. In fact, in 1960 only, Massachusetts, New Hampshire, West Virginia, and Wisconsin could claim that a majority of both houses of their legislature were represented on the basis of population. All right, and more than 40% of their residents could seize control of representation in that. All right, so California had a system where its House of Representatives was based on population, but its Senate Senate had equal representation, much like our federal system. But what happened with that is that you have in California, a state Senate, a single seat that oversaw 6 million people, and another one that oversaw 13,000 people. All right, how does that equal representation to the voters, where you're one of 6 million versus one of 13,000? In Vermont, 11% of Vermont's population could win a majority of its state House seats. In Nevada, 8% of the people in Nevada could control its state Senate. All right, so again, we're talking about malapportionment virtually everywhere in the country. Gomillion versus Lightfoot was huge because it opened the door for the court to step into some of these different disputes. So even though there's not a direct connection between Gomillion and Tuskegee outside of the Alabama connection, the court sees that as a door. Baker v. Carr in 1962, the court says redistricting is justiciable. You have 1964, I should say, Westbury versus Sanders. The court goes ahead and looks at whether congressional districts should be represented on the basis of population, and says indeed they ought to in the House of Representatives. So that leads us to June of 1964, when the court looks at Reynolds v. Sims and states in that both houses of the state legislature must be represented on the basis of population. All right. This was very, very controversial at the time. People said, how can the Supreme Court mandate that at the state level when even at the federal level, the Senate is based on equal representation and the House is on population? How can the Supreme Court mandate that? And the court basically said, simply because of what people do with power, what happens in state legislatures, and how they retain that power. And so Alexander Kaiser, who's a historian of voting, explained, democracy indeed could be undone or circumvented through districting mechanisms as well as through disenfranchisement. Those who wielded disproportionate power in state governments were unlikely to surrender that power voluntarily. So again, you have Reynolds v. Sims is absolutely critical. It's the foundation stone of every single voting rights case since that time, as well as the Voting Rights Act, of course. It's incredibly important, but as some scholars have suggested, it probably promised more than it was able to deliver. The fair and effective representation of all citizens, no longer could the representatives malapportion their districts so that they were able to, a small number of, a small population could be overrepresented in the legislature, but now you have partisan gerrymandering. So it's not done on the basis of the rural folks having much more power, but it's done based on parties. And the court, 4 months before it decided Reynolds v. Sims, considered a partisan gerrymandering case, that we just can't go there. We're not going to step into partisan gerrymandering, and this is what the court has basically stayed with ever since that time. So what do you do when you are a Democrat in a red area or a Republican in a blue area? You're going to go exercise that privileged, awesome, incredible right to vote, and it will mean nothing, because it doesn't really count, because of the way that the parties have so gerrymandered things. That red vote in the blue area, that blue vote in the red area just doesn't count. And so the court, again, 1964, 1986, 2004, 2018, and last June in 2019, and Rucho versus Common Cause reiterated that. How can we fix this? How can you expect a 9-member court, 5-member majority, 1 swing vote, all right, to fix this and make it fair for all people? Would it be better to turn it over to legislators or to the governor, to a commission, something else like that? How can we be asked to fix this? So the court has stepped out of that. I was just saying in conclusion that Gomillion versus Lightfoot and Reynolds v. Sim demonstrate that voting is power. The ability to vote, to have it make a meaningful difference. The delegates to the 1901 Constitution deserve to be criticized, all right? What they did in terms of the product is not great, but the underlying theme of voting is power, I think, is something that the Supreme Court has really focused on and has tried to give words to in that Declaration of Rights in the first section of the Alabama Constitution, that all political power is inherent in the people. And I think we owe a debt of gratitude to the Alabama citizens who brought case against these claims and these things in the Constitution, the Alabama attorneys that represented them, and to the court that decided to take the case and to rule and do the right thing that would bring voting and the power of voting and the opportunity to do that to all Americans. Thank you very much.
A couple of minutes left, but I will open it up for a couple of questions. Seeing none, then we will adjourned for our next panel, which starts immediately.
Good morning, everyone. My name is Scotty Kirkland. I am the Exhibits, Publications, and Programs Coordinator here at the Alabama Department of Archives and History, and I want to talk to you a little bit about our We the People exhibit, and then we'll go upstairs and we can take a look. Very happy to be able to give you this sneak peek today of our exhibit, which opens on Sunday, and I'm even more happy to say that it is almost complete. We have a punch list of less than 5 things left. So as you can imagine, we are very happy that Sunday is still a few days away. We have a couple of things left to do, but you will see an exhibit that is about 95% of the way through. All the documents are in place. All the text is on the wall, and for someone in my position, that's incredibly important. So for a sneak preview, we're happy that you won't have to imagine what each section will look like. It occurred to me as I was driving over this morning that that you all are not necessarily the target audience for this exhibit, because you are, by your profession and your interest in history, already interested in an exhibit of our state's constitutions. And so we wouldn't have to probably, if you all were our only audience, we wouldn't have to work quite as hard to make it as visually appealing. But a few things that we've done that you'll see upstairs is we've chosen an image that represents the era in which these constitutions were debated and signed, and also a quote from an Alabamian or a quote from the document itself that sort of typifies that era. And we really, as our director Steve Murray said this morning, we really did focus in on these documents as turning points. As turning points in the state's political history and what they said about not just a moment in time, what they said about Alabama's place within the broader government, but also Alabamians' role in shaping that government. So we're very happy with the way this exhibit has taken form. We hope that you will be as well. There are 2 films in the exhibit that are currently running. Feel free to take a look at those. One is about the history of some of these documents, the history of the 1819, 1868, and 1901 constitutions. And the second film is on the conservation of these documents, which I know Steve Murray touched on this morning briefly. They had to undergo about 9 months of extensive conservation work to prepare them for this exhibit, to make sure that in displaying these documents during the Bicentennial, we weren't doing any damage to them. So these documents were stabilized, and we made sure that when people are sitting here celebrating the 300th anniversary of 1819, that these documents will still be available to be looked at, debated, and discussed. So we're quite pleased with that. Julian Butler will speak to you this afternoon. He's a member of our Board of Trustees, and this entire exhibit started about 4 years ago when Mr. Butler, during a trustee meeting, stood up and reminded us that for the 150th anniversary of the founding of Alabama, the archives loaned the 1819 Constitution back to the city of Huntsville in Madison County for a period of 6 months. And Mr. Butler, in his avuncular way, politely requested their Constitution back. So we started thinking about then a way that we could do that in a more full way that we could use the document. So we then expanded to a notion of a display that originally had 50 documents, sort of defining documents of Alabama's history. And as we continued to work on that list and continue to sort of winnow it down, because 50 was too much, we really continued to come back to, is what Steve Murray said this morning, was that these 6 constitutions and the Ordinance are really foundational stones of Alabama's political history. And so we ultimately decided that to have an exhibit that had 7 artifacts, which if you've been to our Voices exhibit, you know that 7 is a pretty small number for artifacts. So to take these documents and interpret them as much as we possibly could and to display them in the best possible way. So we've worked on this for 3.5 years. My colleague George Ann Hudson and I both have children who are alive now who were not when we started working on this exhibit. So we're pleased to open it to you today. And there's a website, wethepeoplealabama.org. And so if you're looking for the full text of all 6 of the documents, if you're looking for the images, if you have need of some of the teacher resources that we've created to go along with these, the lesson plans to go along with each constitution. If you'd like to see the videos, if you'd like to see some of the press coverage from Huntsville or some of the press coverage that we'll get very soon, wethepeoplealabama.org is going to be the lasting legacy of this 8-week exhibit. So when the constitutions come off display at the end of the year, the website will live on. There'll be great photography there. There'll be a 3D scan of the room, so the exhibit, both the version of Huntsville and the version here, will live on. I'm not going to give you a history lesson of the Alabama constitutions. That's why you're here today. So I'll just invite you, if you're interested, to come up now with me to the 2nd floor. We have stairs and we have access to an elevator. So I'll go out this door here and meet you in the hallway. When we get to the gallery, if you have any questions, I'll be glad to address them. And thank you again for coming today.